champions. Morning. How are you guys all? Amazing, right? Team? Okay. So before we begin, I just wanted to give a big thank you to Rod Fehlman for being here, for offering his expertise, all of his knowledge to us. So he's worked with my mom for several years, and I always remember growing up and I would hear my mom on the phone with Rod Fehlman. And I knew his name before I even knew the man. So he's always been here supporting us. He's always been here supporting the community. So let's give a warm welcome and round of applause to Rod.
Good morning.
Good morning.
So, what do you guys want to talk about today? Anything in particular coming up that you might want to discuss, or should I just choose the topic? Changes. Right, we're talking NAR stuff, right? That's what we is that what we all want to talk about this morning? All right, let's talk about that. So we talked a little about what caused all this last time we met, and I think I went through some of the math just to demonstrate sort of how silly the whole thing was. And I'll go through it briefly, and then we'll get into some of the nuances of what the changes are going to be. Now, we know the change date, right? Things are going to change August 17th. That's when everything is revised. The first question I get before I get into the actual math of it is the first question I get all the time from the agent. So what about my existing listing contracts that I have? Will they continue to offer and advertise cooperative compensation after August 17th? The answer is no. That goes away, just kind of vanishes as an option. So you still are able to offer cooperative compensation under terms of the listing agreement that you have, but will no longer appear in the MLS site, the CRMLS site any longer. It's going to be gone. All of it's gone immediately. So whatever you have that's pending as far as listings where you're advertising in MLS for cooperative compensation to a selling office, that goes away on August 17th, just so you know. That won't even be an option. It'll just vanish, and it won't be anything that we do any longer. Which kind of begs the question, why do we even pay MLS? So why are we NAR members? Why are we realtors? But I'm going to kind of shelf that discussion for later on. But I have some opinions of where I think this all goes. So let's talk about the lawsuit. So we all know back in about 5 years ago, a group of plaintiffs filed a lawsuit against NAR and several large brokerages in the state of Missouri. And that case, because of COVID, took many, many years to get to trial. And ultimately the case got to trial in this podunk town in Missouri, and with the podunk jury, ended up with a $1.38 billion judgment against all these parties, joint and several. That's what happened. And so now, on this case that really had no merit, it was really dumb to begin with, but given where it took place, the outcome was obviously selected by the plaintiff's lawyers. So let's talk about that a minute. Now that there were a couple holdouts, now everybody by knowledge is settled. The last holdout was Berkshire Hathaway, and they paid close to $300 million to get out of it. So altogether, the plaintiff lawyers have collected over $1 billion in settlement on this Missouri case. They've entered into a settlement agreement with NAR, and I think we know that was $418 million. And the only thing that we were required to do here in California is really no longer have the option to offer cooperative compensation in the MLS. That's really what it's all about here, and that was part of the settlement. So let's kind of break the numbers down. So now the plaintiff's lawyers get $1 billion plus or minus to play with. So where does that money go? I mean, you got a group of representative plaintiffs who say that they were injured as sellers because they were tricked, or it wasn't fully disclosed to them that they were going to offer and pay selling side commission to the party that represented a buyer to their deal. That's what it was about. So here's what happens. Out of that $1 billion plus or minus, the attorney's fees are between 33 and 40%. So it's basically $400 million goes off the top and gets paid to the plaintiff's lawyers. The plaintiff's lawyers can then petition the court for costs. Those are different than fees. And that's $100 million, let's say. So now we're up to roughly $500 million of the $1 billion that's gone to the attorneys, and we're stuck with $500 million left in the pot for all of these plaintiffs that are upset, which most of them aren't. There's 2 of them, but nevertheless, there's how many transactions do you think are covered by the lawsuit? 21 million transactions are potentially covered. So what does that mean each of these plaintiffs get? If everybody files a claim, how much does each plaintiff get out of the $1 billion that has been now settled, paid to settle the case? Try $45. So I think that kind of tells you what this lawsuit was about. It wasn't because real estate agents did anything wrong. It was because plaintiff lawyers who do class action lawsuits fish around for something that they think can make them a lot of money. And this is what happened. This is a creation, a concoction, a scam by plaintiff lawyers to raise a whole bunch of money so that they can do what they do. And they really don't care about the cause here. So were you guys doing anything wrong at any point in time by offering cooperative compensation to a selling office as a listing agent? The answer is absolutely, unequivocally, no, you were not. You never have and you never did. Now, when did cooperative compensation become an issue in the first place? When did it actually become the standard in the industry for a listing agent to put on MLS that we're offering cooperative compensation to the selling office? That happened in the early 90s. Remember when that happened? It was a big deal. You know why it happened? Because the same lawyers that just finished suing saying it's unfair sued because they said it was unfair to buyers because buyers weren't able to get good representation unless the listing office offered cooperative compensation. It was exactly the opposite argument by the exact same group of lawyers. So here 30 years later, now we have this, and now buyers are going to have to work on how they're going to get compensation. Now let's talk about what this really means to us. At the end of the day, I hear apocalyptic comments by the agents. The sky's falling, it's bad news, we're all finished, we might as well go to Truckmasters and start driving truck because that's where the volume is, and we might as well just hang up the license and save our money and do something else. That's what I hear. That's the same argument that I heard when they came out, CAR came out with the AVID form, by the way. As soon as they came out with the AVID form, and agents had to do a visual inspection, they had to complete the AVID, the agents 25, 30 years ago said the same thing. Apocalypse is here, there's no way agents are going to survive now that we have this huge liability to create this analysis of the physical condition of the property based on our visual observations, and now put it on a form that we're liable for. So I've heard the same arguments. So do I think it's going to make any meaningful difference in any listing or selling agent's life a year from now? My answer is going to be no. Do we have a lot of forms that we have to master between now and August 17th? Yes, there's a lot of new forms that do virtually nothing. But they're there. And we're going to fill them out, and we're going to go through the exercise, and we're going to find out how to do that. But what I'm telling you is at the end of the day, keep in mind one thing. In California, this whole settlement nonsense means one thing, and really one thing only. And that is the cooperative compensation from the listing agent can no longer be placed in the MLS. Well, where can it be placed? Everywhere else. So you can place cooperative compensation on a company website. You can put it on the side of your car. All my listings, 3%. You can put it on your billboard. You can put it on your sign. You can put it on your flyers. You can create your own website for your own listings that indicate what the commission is going to be. You can do anything other than place it in the MLS. That's really your only restriction as a listing agent. Are there problems? There's some really big concerns. And there's some hurdles that you guys are going to have to overcome. And the way that I've divided this lecture is we're going to talk about pre-listing, listing, and then selling side. So you're going to have basically 3 areas where there's things to do. The first one we're going to talk about is pre-listing. And what's that mean? That means that you're going on a listing appointment to talk to a seller for the first time. Now, that seller has a computer 99% of the time. And that seller reads the Google feeds as they search the internet. And they've seen the narrative. And we've all seen the narrative. What's the narrative? What have you read in the newspaper and online about this settlement? California sellers, commissions gone forever. Parties no longer have to offer or pay commissions to real estate brokers. Real estate agents on the decline, no more. No more commissions, California, hooray. I've heard them all, I've read them all, and what these headlines tend to do is imply that somehow this settlement eliminates buyer side and listing side commissions in the state of California. If you read those articles, that's not what it says, but your clients aren't reading the articles. They're reading the headlines and the news bites. And they think that commissions are no longer required and aren't going to be paid, and that everybody in this room, including me, now works as a public servant for free.
Yeah.
So, that's where you guys are going to start the ball on August 17th. So you're going to have to come up with a narrative, you're going to have to come up with a soundbite that eliminates that. We're going to go through that in a minute. I'm going to give you a couple of examples that I've had come across my desk already relating to these narratives. One of them, I had a listing agent call me a month ago who had a fairly difficult listing that was difficult to sell. It was like a 2-bedroom house with a 7-car garage, just an oddball product that not everybody in the world wants. Well, they got a full price cash offer. And so she presented to the seller, and the seller says, oh, the timing's perfect because I just read that I no longer have to pay anybody any commission. So as soon as you send me an addendum that says nobody gets paid a commission on this deal, I'll sign the offer. That's the one thing that we saw. And it goes downhill from there. That's the best one. But at the end of the day, you need to anticipate that your sellers, when you go on listing appointments, believe that commissions are no longer legal in the state because of this settlement. And it's based upon all the misinformation online. So you need to have a canned response to put that to rest right away. As soon as your seller starts barking about commissions and the settlement and they're not lawful any longer, you need to fire back with some details. No, that's a Missouri case where there was never a final judgment entered, and the only thing that we do is we have to disclose the commission, just like we always have, but it's business as usual. That case has nothing to do with California itself, which is true. The settlement does, the case does not. So you need to have a narrative with some detail that makes you look like you know what you're talking about with respect to the lawsuit, the settlement, and the commission. That way it goes away right away. Another thing, some of them that are a little more savvy will understand commissions are illegal, but they will believe that they're able to not pay a selling side. So they say, yeah, I'll pay you your, whatever you get, but I'm not offering anything under any circumstance to a selling office. I'm just not going to do it. And I think we have to kind of educate the clients that, well, you can do that if you want, but then that leaves one option, really, and that is if you're able to find somebody, you can be a dual agent for 50% of the commission. Or you can write into the contract as a higher amount if you're a dual agent. But at the end of the day, you're going to be a dual agent if you're not going to pay anybody. Who's going to show a house here if you know for a fact you're not getting paid for it? Do we want to do that? Would I want to lecture to you if I know I'm not getting paid for the next year? Well, I love lecturing, but I'm not going to be here. I'm not going to talk to you. I'm sorry about it. If I'm not paid, I'm not going to be here either. The reality is, I like working for money, and you guys do too. And I'll say it. That's the way it is. So you need to be prepared also with a canned response. This is all under the pre-listing narrative. It's the pre-listing headline of why that's important. Because when they say, "Hey, I'm only going to pay you $3," you say, "Well, then you're not going to get a buyer." I just have it like a canned, kind of sarcastic maybe response. You're not going to get a buyer because who's going to show your house for free? Nothing's changed with the matrix in California. Our listing and selling process is exactly the same as it was last year, and the year before that, and the year before that. And so the only way you sell it is if we offer somebody money who brings you somebody who pays you maximum value for your house on terms that you agree to. If you do not offer any compensation or allow me as a listing agent to offer compensation in connection with one of your deals, nobody will show your house, and you might as well not even list it for sale. You might as well give it away to somebody because it won't work. And you need to be able to, again, a two-step sort of canned response to address those two important issues. One is the lawsuit, and one is the commissions that you're gonna need to play with in order to attract a buyer. And if you don't have those answers, your client's gonna ring around you. They're gonna think, okay, I'm onto something because they don't have an answer. And I've already seen it in play. So option for just right out the gate, when you guys go home today, I would figure out what kind of a canned response you're gonna use for both of those scenarios. Just anticipate every single house that you go into with a seller is gonna challenge your right to commission because they think it's not lawful. And you need to fire something back. That's a Missouri lawsuit, it has nothing to do with us, it was never converted to a final judgment, and all we have to do here in this state under the law is disclose a commission. Nothing's changed. You read it wrong. Okay, well, I'm not gonna pay selling side commission. You can do that. Who's gonna show your house? If you really wanna sell it, we have to do it just like we did before. The business model in California has not changed. If you wanna sell it, you gotta offer it or nobody's showing it. I mean, you have to be that blunt and have a canned response that's affirmative. And if you do that, your seller will abandon the claim and move on and probably do things that you want them to do. I had a client, I gave this lecture a week ago for another office. And after I gave these sort of canned responses, literally that afternoon, the agent went out on a listing appointment, and sure enough, what did the seller say? Exactly what I told them they would say. That they read that we don't have to pay commissions any longer. And the agent went through my canned response, and the seller said, oh, okay. And then when it came to paying the listing selling side, same argument that I told them would come up, and she fired back, and the seller was happy with it and said, okay, well, let's just get it done at 5%. And you can offer 2.5 to the selling office. They got exactly what they wanted, the price the house is listed, and I think it's an escrow now. So just be mindful that that's your first duty as a listing agent, is to put those two arguments to rest right up front. Now, leave that table, you have the listing. Now we're gonna talk about the actual agreement itself, just ever so briefly. There were two versions of the new revised residential listing agreement. There was a good version that came out 30 days ago. There was a revised one that came out 2 weeks ago. Which one do I like? The first one made some sense. The second one makes no sense. And the one we're going to work with is the one that makes no sense. Why does it make no sense? Because the first one that came out allowed you as a listing agent to go through the front page of the listing agreement, and it broke down commissions very nicely. Meaning, if I represent you only in a transaction, I get 3%. If I'm a dual agent, I get 5%. If I'm authorized, it had a box there that said, I'm authorized as a listing agent to offer this amount to a selling office as a component to any offer, any counter offer we propose on your behalf, or after that we accept. So it allowed right in the listing contract authorization for the listing agent to pay commissions on their behalf right in the contract, just like we have today. What did they remove in the most recent version? That option. So it doesn't exist any longer. So what does that mean? That means we have to create it. We either have to use paragraph R and write that in, that the seller authorizes listing agent to pay 2.5 to a selling office for a total of 5. You can add that language in. It was already in the previous edition. Not in this one, but it was in the previous edition. So you're either going to go to paragraph R and create the right to offer selling side commission, or you're going to use an addendum to the RLA to do it. Either way, it's more complex than it was before. So just be mindful of that. Now we left being at the listing side of it. Now we're just talking about the listing contract. Otherwise, the listing contract, as it's revised, is pretty good, by the way, other than that one omission. What you need to be concerned about, paragraph C1, C2, and paragraph R. When you look at it, that's what defines your right to commission, right on the front page. It's been revised to look a lot like our RPA structure. And I think that was a really good change, because the RLA was looking kind of straggly the last couple of years. And I think I told you in the past why it looks so straggly, because that particular version of the document was created 22 years ago. And it's kind of like, I tell people this all the time, it's kind of like a craftsman house in downtown Upland, Or somebody decided to add a room on the side, and then they put a sunroom over here, and then 20 years later put like a funky looking second edition, and now you drive by the house, you go, wow, that looks weird. But that's because everybody kind of added to it over time in a way that it didn't make any sense. The same thing happened with the RLA. It had been tinkered with and monkeyed with to the point it really didn't work well together. But now this one does. So it's basically a good agreement, except you guys are going to have to address the cooperative compensation issue in either paragraph R or by a separate addendum attached to the RLA. And it's going to have to say something like, the seller authorizes listing agent to offer 2.5% to the selling agent as cooperative compensation in connection with any transaction. That way you have a written authorization to offer that when you're talking to a selling agent. Yes, sir?
We couldn't write that in the listing agreement where it says additional terms?
Additional terms is fine, that is paragraph R.
That's paragraph.
Okay.
Yeah, so that would be it. Yeah, I just want it in the box where the paragraph, where the commission is addressed, and that's it. Okay. I wish they would have left it in.
Yeah.
But they didn't, and so here's the go around to it. Now let's talk about compensation. Because now the next thing is you got your listing, so you met your seller, you convinced them the NAR settlement didn't make commissions illegal. You've convinced them that they should offer compensation 2.5%, say, to the selling office, or nobody's going to sell their property. You've gone through the listing contract, the RLA, and you filled it out, and you have paragraph R completed as we discussed, so that you're authorized to offer 2.5%, so you're ready to go to market. You're good to go. The next question is, how do I convey that I'm offering commissions to the selling agent so they'll show my property? Well, I mean, how do we do it now? Right, you put it in the MLS, and every agent in the world looks at it. They know what you're offering, and they're bound to that number because it's enforceable under arbitration and mediation provisions through the MLS. So we have that. So they eliminate that. Now we're eliminating that, so it leaves it kind of in a wild card area. What do we do? How are we going to do this? Well, like we talked about, you can list it on company websites. You can say offer the commissions there. It can be anywhere online with your listings. Wherever you advertise your listings, you can put it there. You can put it on every single flyer you want. There'll be a full disclosure of what you're offering. It can be on any sign that you have. It can be on any site that you have. It can be on the side of your car, as we talked about. You can have it any place. You can advertise that your seller is offering cooperative compensation to the selling agent anywhere in the world, on any surface, on any media, except MLS. And that's up to you. Yes, sir?
So on the MLS, would we be able to put something like for compensation, text this number, or go to this link, anything like that, or no?
That's a great question. So this morning I actually did some research on that to see what we can do. So you're obviously allowed in remarks to put sellers offering concessions. So you can put seller concessions. There will be some place to put seller concessions. And the question is, can you say seller concession / compensation? Anytime you use the word compensation or anything to do with what the broker's offering to pay the other broker will be struck from the site. So, but what you can do is you can say seller compensation 3% of the purchase price. You can kind of secretly put it there. So you can indicate seller compensation as a percentage of purchase price or as a dollar amount. You can start there if you want. I always thought it would be pretty clever just to come up with a code word. I think I brought this to your attention the last time. And my code word's the same, and I shared it with over 2,500 agents so far. They really like Geronimo. And so there's nothing MLS could do about it. For Geronimo, see the list, call listing agent. And then they would call up, and then you tell them what the Geronimo is. I mean, if I talk to enough offices, that may be the word that gets used for code for commission. Now, how stupid is it that we have to go around everybody's back just to offer commission to get a house sold? How stupid is that? Why are you why are you a member of NAR?
It serves no purpose.
Yeah, I mean, what does it serve? If you were not a member of NAR, would that hurt your business at this point? No. Can you put commissions on a Zillow site? Can you offer Zillow to?
Yes.
Yeah. So they'll take it. So that's another site you can go to, and they'll take your listing and they'll advertise it free, right? And you can put your commission on there. So I mean, there's a lot of different public ways you can do it and still get your message out. It just won't be MLS. Yes, ma'am.
Can you put sellers offering co-op concessions?
Nope, nope, it's gotta be seller concessions, either a dollar amount or a fixed percentage of the purchase price. That's all they're gonna allow you.
Seller offers buyer's concessions 2%,
You can say that.
and that's good enough.
Yeah, that's good enough. You can do
That's
it.
good.
I checked that this morning and they said you could do that, absolutely 100%.
Seller
You put it on showing time?
Seller offers
No, you
buyer's
cannot.
concessions
Not
2%.
showing
No,
time.
showing time, they just came out with that. I checked it this morning.
Okay.
They said absolutely they're gonna strike it. So you can't do it, unfortunately. Yeah, great question though.
But we
I-
can put signs, I ordered some signs hopefully, that can say, we offer broker co-op on the
Yes.
sign out in front of the house.
Doesn't matter to me.
Okay.
It doesn't matter to them. Yes, ma'am.
Now, with the seller concession, so like, let's say someone, you said that's gonna be striked out, will the board end up like, how about the board, will they start fining?
I think they just won't allow you to enter.
Okay.
Yeah, I mean, they may end up fining you eventually. They love fining people.
Yes,
They just enjoy it. I
They
mean,
don't help.
yeah, they're very little help these days.
Yeah, very little.
I mean, honestly, and I'm kind of soapboxing here, but I don't see a bright future for NAR or MLS services. Because I think there's a lot of other better ways to do it. Especially if you're not, I mean, if there's all these other sites, where does your buyer and seller, where do they go to find properties and sell them? Everybody goes online.
Yeah.
So the only real practical purpose that I can see of an MLS for you or CRMLS is what? To offer the commission that you can't offer any longer. Or to get you punished if you put your sign out too late, or you enter your listing too late. I mean, right? I mean, what do they do otherwise?
Doesn't help.
Yeah, they're no help. So I'm not, in fact, it was interesting. I mean, I was invited to lecture at one of the local boards recently. And I've worked with the board for a long time, and I told them, I said, I'll lecture and I'll talk about this topic. But I said, I'm just letting you know right now that if they ask the right questions, I'm gonna advocate against getting rid of this board. And if you still are okay with that, if that question comes up, I'll speak for your office. But I said, I know if it comes up, I'm just warning you in advance that I'm gonna advocate getting rid of this office here, and you won't have a job if my clients listen. But I said, I'm more than happy to go there. And I did go there, nobody asked the question, so we never got to that point. But they still have jobs, and they're still finding everybody in this room. So you're rest assured, if you don't enter it in time, and how many days do you have to enter a listing? 2 days. And if you have an exclusion from the listing, an SELM, and you accidentally publicly market it, how long do you have to enter it? Then 1 day. And if you don't enter that after publicly marketing it accidentally, how much fine is it for accidentally publicly marketing it when you have a seller exclusion from listing? Yeah, $2,500. Yeah, keep in mind, if you have an SELM form and you have it off, it's not listed on MLS, and you accidentally advertise it on a public site anywhere, if you advertise it anywhere publicly, that's a $2,500 fine. That's it, that's one of the largest.
What about one of those coming soon signs on a property? Is that a fine also?
It is if you go past the time frame. I mean, you got, how long is a coming soon good for?
Well, I don't know, but if they haven't signed the contract, I wouldn't know.
Yeah, typically speaking, a coming soon is a 21-day lead. For new construction, it's longer, but there are very specific rules on coming soon. If you violate those, I believe it's also $2,500 fine. I mean, these are the guys that you're not able to put on MLS any longer. You can't put your commission, but you can do all this. Yes,
I
ma'am.
have a question about the MLS. If we
Yes.
get rid of the MLS, the Zillow gets all their information from the MLS. If we get rid of the MLS, we're still gonna have to pay all these, we're still gonna have to pay somebody. So we're gonna be beholden to Zillow because we're gonna have to input our stuff to Zillow. So
Probably.
that's gonna replace the MLS.
Yeah, maybe, that's what I see. That's kind of what I see happening. Yeah, and maybe this whole scam was put up by Zillow, I don't know. But I mean, at the end of the day, they're gonna be the big winner here. And how much did they pay in settlement, by the way? How much did
Zero.
Zillow pay? Yeah, zero. They wouldn't pay anything, yes, ma'am.
Right, to clarify, for concessions, when you
Yes.
say you can put concessions in the MLS, that does not go towards the commission.
It can, it doesn't matter what it goes to, you just can't state what it goes to until the agent calls you. So you can put seller concessions at 2% of the sale price, 3% of the sale price, you can put that. You can't put that it's designated to the selling office. You can't put that that's for commissions.
Until
You
they
can-
call.
Until they call, or they email you, or they contact you.
Ron, you put that in.
So
the
we can
agent
put
contract.
But that's good code right there.
That's fine code, as long as you have code that you know what it means. Any questions before we move on? This is your day, so any questions you have, just ask them why we're going along.
Just
Sir?
want to confirm that it's in the agent remarks, seller to pay, up to 3% of concessions.
Concessions, seller concessions, magic words. Anything that indicates or implies cooperative compensation, they're gonna strike, and in answer to somebody else's question, at some point, they're gonna probably get excited and start finding people. Yeah.
Now,
Yes,
as a
they love to do that.
As
Go
a
ahead.
selling agent, let's say we go on MLS, we see that concessions, 3%, for example. Now, do we have to send the buyer compensation to have them on the hook for that, for our commission being advertised?
Yes, you do. That's our next topic, so let's just roll right into it. If you're a selling agent, you have to do things that they're requiring you to do. Nothing dramatic, but you have to do things in a different order than we did it before. So the first thing is, yes ma'am?
What happened with the listings we already have in this contract?
On August 17th, the MLS, the cooperative compensation portion of that listing goes away, everything else stays the same.
Yeah,
They're gonna
but
do
mainly
Yes.
The contract we already signed with the sellers.
You're still okay to offer that compensation, so you can still offer cooperative compensation under your existing listings, but where you have it in there right now, where it says 2% or 3% to the selling office, that whole block's gonna go away, it's gonna vanish. And so it won't be online anymore,
Okay.
unless you go to Zillow and pay them to dinner. But it's not gonna be on MLS. August 17th, you're gonna wake up, you're gonna have a coffee, you're gonna go on MLS, and all that stuff's gone. Just like that. Okay, so here's the new scenario. We talked about listing, pre-listing. We went through pre-listing. We said, okay, well, the narrative commission's illegal. We talked about how to defeat that. I don't wanna pay 6%. I don't know anything to the selling office. We talked about how to build a canned response to that. Now you got a listing contract. We know how to advertise the MLS now. You know how to advertise selling commission, you know the go-arounds, you know where you can advertise for a cooperative compensation. So now the listing's up and running and rocking and rolling. You got that done. We just went through the whole process under the new rules. It's that simple. So now the question is, you're a selling office, you're representing a buyer now. So we're gonna put another hat on, and we're gonna talk for the rest of the day about that hat. So we're now selling agents. Everybody in this room represents a buyer as a selling agent. Okay, you're a buyer as a selling agent. And so what do you do differently? Here's the first scenario. You're at the desk here in the office, buyer walks into the room. And he says, hey, I'm looking for a house. You know anybody that can help me find one? What do you say? Hey, yeah, I'll help you with it. So the NAR settlement wants you to do two things at that point. Before you provide any information offline, printing any market information, take them on rides, show them properties, suggest properties. Before you do any of that, CAR wants you to do two things. I disagree with them, so we're going to talk about what I'm going to recommend, but I'm just going to tell you what CAR wants you, what the NAR settlement wants you to do first. Before you even open your mouth and talk to the client and say good morning, you have to have your hand on the print button for an agency disclosure. Flat out. And I can't get around that. So that's one thing, you're gonna have to have those ready to go and say, hey, this is just paperwork, agency disclosure, the law says I have to have it. That's one thing you can't get. The next thing they say you should have, this is the NAR settlement, this is also CAR, is a buyer representation and broker compensation agreement. So this new buyer that just walked in, you haven't seen them, you don't know who they are, you don't even know what they're looking for, CAR and NAR settlement want you to then have them sign a broker representation and broker compensation agreement. Now at that point, when I push the print button and I print that out, that says it's a 5-page document. And it says all the things that they're gonna do for me and they're paying me money, what's that buyer gonna do?
To walk away.
I'm walking away thinking about it. So I know they're gonna walk away. So the way I'm proposing that we do it is different from them because I want you guys to stay in business. And sometimes what these guys want us to do, we're just gonna have to do it differently to stay in business. And staying in business is more important than filling out the form, in my opinion. So my view is always prioritize the buyer, whatever it takes to get the buyer comfortable. And if you can get them to sign the agency disclosure before you provide information to go for a ride, that's good. If you can't do it, we can work around it. I mean, you're not gonna get disciplined. This is their recommended way to do it. Okay, this is how they want you to do it. So yeah, you should have an agency, in a perfect world, have an agency agreement ready to go. That's what you should have when you meet the client and take them for a ride and give them information. My view is, that the buyer representation and broker compensation agreement don't come into play until you write the offer. Okay? Because then you know what the other side's offering, and you can write that into your broker compensation. You're right. If you're writing a buyer representation and broker compensation agreement without knowing what the ultimate seller is offering you on the property that your client ultimately makes an offer on, maybe a week, 2 weeks, or 3 weeks later, well, how do you draft it? I mean, you're gonna put in there, he's gonna pay you 20 grand, what's the buyer gonna do? Out that door faster than I can walk. And if you say 3% of the purchase price, regardless of this, that, and the other thing, he's out the door again faster than you can walk. So, my recommendation is you shelf the buyer representation and broker compensation until such time that you're presenting an offer. Because at that point, you've got a whole bunch of documents you're gonna include for the buyer anyways. And that'll just be one of them that you will explain. Okay, here's what we're doing. We're gonna have you sign this, buyer representation and broker compensation agreement. This allows me to get paid from the seller. Boom, here's the offer. This is the terms of the offer. Boom, they'll sign that. Now you're golden, you're ready to go. The code only requires that you have the buyer representation and broker compensation agreement at the time the offer is made in order to be entitled to commission. So that's why I'm saying that's the way we should do it. Is write it with the offer. First, second, just like that. BRBC, RPA, out. That's it. That's my recommendation for how we do it. Now let's talk just briefly about how we draft that thing. Paragraph H is really where the broker compensation is defined in the BRBC, which is the buyer representation and broker compensation agreement. It's in paragraph H. And I'm going to recommend that there's several ways you can do it. One, your buyer can agree to a fixed amount, theoretically, like 20 grand. Never going to work. Two, buyer can agree to a percentage of a purchase price, but again, we don't know what the seller's offering, so it's not going to work. Number three, if you're writing with the offer, that works because now you've already talked to and confirmed in writing what the seller is offering. Because presumptively, before you write an offer, in today's market, after August 17th, you're going to somehow contact the listing agent or look on their site and determine how much they're offering. And then you're going to just draft the paragraph H and then also your RPA exactly to match what terms they're offering cooperative compensation. And that may even be a call. I mean, my recommendation is that you as a selling agent, with every single offer, make a call. Make a call to the listing agent or send an email out. Is a seller offering cooperative compensation? I've got the best buyer in the world, and we'll go look at that property if that's what you're offering, that kind of thing. And then once they confirm in writing, then if your client wants to make an offer on it, the buyer representation and broker compensation, exact terms that the seller's offering, and you know what it is in advance. Yes?
You're saying have it confirmed in writing. Would it be better to send them a text and ask them and then have them respond?
Doesn't matter to me. You can do it by text. You can do it by email. You can do it in writing, fax. You can do it however you want, as long as you have something in your file from a listing agent that says, if you bring me the guy, you get 2.5%. That's all I want to see. Something in writing that we can hang on if they screw you later and I have to go after them. I want it in writing. All right? That's all I want. So something in writing signed by you. Doesn't have to be an agreement, just a confirmation is enough for you guys. So now you got that. Now how do you write it up in H? My suggestion is, in order for the buyer to be comfortable, you can't just have them pay you. It's going to have to be something that's conditioned, right? You're going to say something like, buyer agrees to pay me 2.5% of the sale price, offered and agreed to be paid by the seller as sole compensation under this agreement. That way the buyer knows if the deal don't work or if something happens, they don't owe you any money. My concern is that buyers in this state in particular aren't going to sign any agreement with you that looks like they're paying you by a check out of their bank account. And that's bad for a lot of reasons. First of all, if they're paying you 21 grand or 30 grand, it probably disqualifies them from buying the house that they're buying. That's probably what happens first off. And secondly, if they see something that says, I got to pay you money, they're going to run for the hills and not even talk to you. They'll probably just go right to the listing agent and then deal with them. So it has to be written in a way that's acceptable.
Can you repeat that? What did
I
you
will.
say?
And there'll be newsletters that come out, but it's gonna basically be, buyer agrees to pay 3% of the sale price, negotiated to be paid by the seller as broker's sole compensation under this agreement. It's tricky language. What it does is that it's narrowed down to a fixed amount. It doesn't really bind them to pay you if it closes, but it authorizes you to get paid, and it satisfies the requirements under the law for you to get paid once you actually fill out the offer. Now, we talked about 2 forms so far when you're a selling agent. The BRBC, which is what? Buyer Representation and Broker Compensation Agreement. Please do yourself a favor. Take that home and read it 4, 5, 6, or 8 times. That's a new form for most of us. You need to understand it. Just read it. RPA, we talked about that. And then we have a third document that's now going to be required as part of the trilogy. And just think about it. When you're a seller, when you represent a buyer as a selling agent, there's a trilogy of forms you need at a minimum. The BRBC, the RPA, and then there's one other form. What would it be? Yeah, SPBB. Seller's Payment to Buyer's Broker. And paragraph 3G3 on the RPA cues SPBB. So the way it goes, BRBC, RPA, paragraph 3G3, SPBB. That's the trilogy that you need on every single deal you write after August 17th. And who do we have to thank for this? The guys at NAR that you pay money to, that represent your interest. Those are the guys that you have to thank for the documents. Any questions about this so far? VA offers are still kind of up in the air. Remember, VA cannot pay commission. Remember that? There's been some prattle going on that VA is changing the rules to allow their buyers to sign the BRBC.
That's an illegal contract.
But at this point in time, I have not seen any formal changes in the law that allow a VA buyer to sign the BRBC. Okay?
Yeah.
So in that case, you're going to have to use this language, which makes them, they sign it, basically authorizing you to accept the seller's offer as everything under the contract. That's why I drafted it the way I did, because it works for the VA until I see something in writing, and also works for the standard buyer.
Couldn't you just state buyers aware, selling agent to be compensated X amount of dollars?
No.
No?
No. There's a couple problems with that. So the question is, can I just say, keep it very vague? And the answer is no. CAR has already said that it's invalid, the form, unless there's some way to calculate what the buyer would owe you. So it has to be a fixed amount or percentage of purchase price. It can't be anything other than that. They've already weighed in on that. They figured we're going to do that, and so they weighted it already. Okay, so let's go through the whole process one more time from beginning to end, because this is kind of a lot of material, but it all relates to your life 30 days from today. 40 days from today. Maybe close. We're getting very close. So here it goes. What is it? No, it is like 15, 16, 16, 20 days from today. Your pre-listing. The first thing you do is have your canned response for why commissions aren't illegal. Second, you have your canned response for all the reasons why the seller needs to offer buyers compensation, cooperative broker compensation. Then you get the listing signed up, and the next thing we do is figure out how we're going to identify that we're offering cooperative compensation. You've got to figure out how you're going to do that. Seller compensation and broker remarks and agent remarks, maybe we'll do that. However you feel you don't want to do it, you got to remember, you can't advertise cooperative compensation in MLS. So however you're going to do it, get your business model ready to accept that. Whether it's your own website, through a company website, through Zillow, however it is you're going to offer it and publish it, figure that out. Then after that, if you're representing a buyer, then remember, you're going to do things a lot differently, but really the same. I mean, it's a lot differently in terms of forms, but we're getting to the same place pretty much at the same time. If you meet the buyer, as soon as possible, get them to sign an agency disclosure. NAR settlement specifies that's something we should do. So try to do that. Oh, hey, you're looking for a house? Here's a little agency disclosure. The law requires it if you feel comfortable getting them to sign it. I'd rather have that. Keep in mind, once you've shown them properties, once you've given them information about properties without the BRBC, they're technically not tied to you to pay you a commission yet. But I think the upside of being able to continue to build a relationship is better than the downside of missing a lot of at-bats for buyers who bolt when you try to get them to sign the BRBC. So I take that chance myself. So my recommendation is, once you finally build a relationship with the client, you've provided all the documents, they have property, you've shown them properties, they pick one out, now you got your trilogy. And what is that? That's when the BRBC gets signed. I told you the language to use for the commission, that's benign. Then you got the RPA, in paragraph 3G3, box check. That then gets you to the third document, SPBB. And that's it. If you do not have a buyer representation and broker compensation agreement, by the time the buyer and seller sign the purchase agreement, under the new law, you will have no right to commission. Okay? So that's why I'm saying you do need to have BRBC at the time you do the offer, or you will not be entitled to commission as a matter of California law. Yes?
Do you have to send that to the agent when you?
The agent doesn't need, you don't need to send it, but the agent can request it. In which case you're obligated to give it up, and if it's not there, they have no obligation to pay you any commission. Okay? So the BRBC, even though we're shelving it until the offer, it's still an integral part of your transaction. Again, if you do not have it signed at the time that the offer is submitted, you will not get paid. Okay? Yes?
But we can't send it, that's it, when we send our offer to get signed by our buyer, we can send that form at that time?
The BRBC?
Yes.
You don't have to send it.
No, send it to the buyer to sign?
Yes.
Or send it prior to you send the offer?
I would send it all together. I would send the whole, I just look at it, when I make an offer, I'm sending a trilogy over.
Okay.
Those 3 documents at the very minimum. Every time you do an offer from August 17th, you're gonna have the BRBC, the RPA with 3G3, and the SPBB. Simple as that. Now, let's take a step back a minute. How many of us have heard this whole process explained in an overly burdensome and complex manner for the last 6 weeks, 8 weeks? Yeah, all of us. I mean, we're all overwhelmed because of all these new forms. And how many new forms do we really have? 21, right? And they're all worthless. But I gave you the ones that you need to have. The ones that get you paid and keep you legal are the ones we talk about today. And it's very simple. So just remember, once we launch August 17th and you wake up and you start doing business, just remember, keep it simple. I need these 3 documents, and then we can expand on the other forms later. But if you follow my little roadmap, it'll get you 99% of the way through all this nonsense. Yes, ma'am.
We need to sign the
BRBC? Yes.
Each time we brought a offer for the same client.
Yes, I would. You know what I would do? That's a great question. So, the question is, should I do a BRBC every time that I write an offer? Yes. And I say absolutely yes, because then you have one specific to that address. I think that's an excellent idea. Again, NAR and CAR don't want you to do it that way. They want with just a generic description of real estate. I think it's better to do it with the offer, because then you can say, we're making an offer on 123 Snuffleupagus Drive. And that's what the BRBC says. It says 123 Snuffleupagus Drive. Then you get to the RPA, 123 Snuffleupagus Drive. Then you get a SPBB, what does it say? 123 Snuffleupagus Drive. That is a standalone package. And if any problems come of it, there's no question about what each one provides to. Yes?
So what happens if the selling or the listing agent only offers 1%, and you want to get obviously 2 or 3%?
Okay, you have 2 options. I mean, either if the listing agent says, look, we're only offering 1%, and that might be the case. I mean, we don't have any discretion there. You can either say, look, I've got a really good buyer. He's interested in multiple properties. This one he has some interest in, but without, he's going to go for these other ones unless you offer me 2. Really, I mean, that's really what's going to happen. You're not going to steer, but you're obviously, he knows what you're going to do. You're going to say, hey, this is a really nice property over here. Just don't look, the fact it's got 9 pit bulls next door is really not a problem. I would really go with this one over that one. But the reality is I would negotiate and say, look, get me 2% in writing and I'll send the offer over on a really solid buyer. If you can't do that, you have 2 options. You either if the listing agent says, screw you, I'm not paying anything, right? That might be the case. 1%'s it, that's all I'm authorized to do, and we're not moving. All right, your options are, two options. Accept the 1%, write the deal, and go. Option number 2, accept the 1% from the seller, write the deal and go, and then get a percent from your buyer. You
And
can
on
do
a
that.
different form, so not putting that on the BRBC.
It would be on the BRBC.
So then
The BRBC it would basically be saying, he agrees to pay 2%, one from the seller and one from the buyer, okay? And then the clearer you can be with it, the more enforceable it is. How many of us are gonna ask our buyers to pay us out of their pocket? Yeah, some might, and maybe you'll have success, but I think keeping the business model close to what it's been for the last 30 years is gonna benefit all of us. If
And the
we
date
all,
doesn't matter?
what's that again?
The date on the BRBC is not gonna matter, it's the same date?
As long as it's at the same time concurrent with the offer, it doesn't matter. Doesn't matter. The only risk is if you don't have a BRBC signed and you show a whole bunch of properties to your client, and then they go with somebody else and write an offer, then you're out. So, but again, I don't think buyers are gonna sign these things. I just don't think they're gonna do it. So I would take the chance and say, this is part of my business risk. I'm intentionally not gonna burden my client and have to explain to them that they're gonna have to pay me money on this 5-page single-space form. I'd rather build the relationship. Once they're comfortable with you and you write an offer, now you got it done. But if you meet somebody off the street, I mean, if he goes over to this, whatever stores are over here, and meets somebody and says, hey, let's go look at properties this afternoon. Here's a 5-page document that says you're gonna pay me if I find something for you, and then here's the agency disclosure, which is another 2 pages, 7 pages of single-space stuff. What's this guy gonna do? What's that buyer gonna do? He's not gonna sign anything. He's gonna say, I'll get back to you. He's gonna shake his head, close the door, and lock it. I can let him back in. All right? Any questions? I mean, this is, I don't want to burden you too much with it, but we'll go over the same stuff as much as we have to so that you guys understand these main points. Again, keep it simple. Don't make it complicated. What I told you is really all you need to do deals on August 17th. Okay? Did you have a question?
Yeah, I have a question.
Yes, sir.
Do you think better to sign the BRBC form or the so-called mini BRBC form, the property showing something, the form? When you're sending offers to multiple properties with different percentage of the commission.
Yeah, you don't have to use, if you want to have a BRBC form signed, if your client will sign it and they don't have a problem, it's always better to have it signed before you go and show the properties. And fill it out for each address. I mean, if you're going to see 5 properties, if you're going to use it that way, then the way you would use BRBC, if you're not going to do what I suggested, you're going to take a client that you know and already have a relationship with, and they'll sign a BRBC form up front. If you're going to see 5 properties, address of each property, all 5 need to be in the BRBC form. And then you can certainly go show properties, and now you have a right for 30 days to commissions if the deal gets done. Yes, sir.
To the point of the 1%, a lot of agents have talked about asking for closing costs and using that for commission. Could you do the other 1% in closing costs if you disclose that?
You can negotiate anything, but again, the way it's going to be advertised is it's going to be advertised as seller commission, as seller concession, as a dollar amount or a percentage of sale price in MLS. That's all you're going to be able to see. But then as far as what you're entitled to, or as a listing agent to offer, that's going to be based on what you put in paragraph R of the RPA. You'll have a fixed amount that you can offer that to somebody else. And it should be an easy sale to a seller. You can say, look, I'm not getting double, but this allows me to offer that to the guy that's going to probably bring the buyer and make your property stick out. But it has to be in the RPA. You're going to have authorization to do that. Okay? Somebody else had a question. Yes, ma'am.
I've always been on the listing side of things, and I really think it's really in your offer proposition when you approach a seller. What is your offer proposition, right? What are the things that I'm going to get? What are the values? What are all these things? So I've never really had an issue with that, and explaining kind of what you explained about, this is why we should offer out a broker compensation. If you don't, you're probably going to get less buyers. You're not going to sell the house for the price of the terms that you want. Secondly is, I like to make things really simple, and I think for me, if I go into a car salesperson, right, and they automatically want to take me to the finance department, I kind of have a little problem with that. It's like, wait a minute a second, I want to see cars first. But if you articulate it in a way of hey, let's go to my office. I want to get to know you a little bit, exactly what you're looking for, what is your vision, and you build that rapport a little bit. Hey, listen, you know what? I just need you to sign this because we had a conversation, and they sign it, right? Because now you've kind of built a little bit of a rapport, and then you go out, and now you're showing them cars, now you're doing all of this other stuff. I think they're going to be a little bit more open to signing the rest of the things because you've built some rapport with them. Now, I haven't really been a lot on the buyer side, but I've mostly been on the listing side, and it's never been an issue for me, the way that I articulate it and I explain it. So I'm trying to really learn the buyer side and making it super simple.
Yeah, I think with these changes, the listing side pretty much remains the same. I don't think there's apocalyptic changes on the listing side.
Correct.
Certainly the agents on the buyer side, the selling agents, are going to have a little more work, just simply because of this BRBC and the sequence of documents. But once you get the sequence of documents, if every offer has that trilogy, those 3 documents, there's nothing that can go wrong with it. I mean, you've got everything that you need to earn a commission. And again, the only wild card is confirming it ahead of time with the listing agent. That's going to be another step that all of us are going to have to go through, and you're just going to have to sell, hey, I negotiated in advance, see what it is, and then put that number on your BRBC. Yes, ma'am.
So is it true, I have 2 questions. One is it true that this settlement expires in 7 years?
I haven't heard any such argument about that.
Because it's in the, I thought it was in the settlement.
It may be. The settlement's 108 pages,
Right.
so I only went through the portions that apply to us. If it expired,
I did see something.
Them in the lawsuit.
yeah, I don't know. The payment is over a 4-year term, but as far as
So I was
sunset,
just curious after 7 years.
yeah, I haven't heard anything about a sunset provision.
Okay, so
That was on page 109.
Yeah.
Question
Yeah,
2.
right.
Question 2. So is it true that if we get the BRBC signed before we start showing them and we put the compensation to be, it has to be exact, 2, 3%. Can you put up to 2%, 3%?
No, they want an exact amount.
Okay, with that said, and then I go show property and I put 2.5%, but they're offering 3. I was told that I can't accept the 3 because it's already in the contract. But I can add an addendum now.
That's correct.
Okay.
Yeah, that's correct. Whatever your max is, you have to have a max. You have to have some way to calculate it.
Okay.
And so if you put 2.5% and the agent says, hey, it's 3, you can do either redraft the BRBC at 3% with that address, or you can do an addendum to the BRBC.
Oh, true.
Either one. I just redraft it. We're going to be so comfortable. The BRBC is going to have to be in every file from this point forward. So you're going to be very intimate with that form and very intimate with the SPBB. Those are going to be forms that we're all going to know and love very, very well after August 17th. Yes, ma'am.
I have a client who is looking into the new builds. Would that be the same requirements for them as well?
You mean new build is a new construction?
New construction.
They have their own contract.
They have all their own documents and contracts, but if you're representing a client as a buyer in a new build, you sign in like whatever their protocol is, but then you still would need the BRBC form signed, and also the agency disclosure if you're representing. So that would still be, but you would not be presenting a BRBC, a RPA, because they'll have their own 450-page purchase contract, which basically says what? What does the builder contract say? We're going to build a house, it's going to fall apart, and they'll have no right to sue us. And then we're going to bankrupt the LLC that we used to build. Any questions? I'm here for you guys today. I'm not going to talk about anything else. This is what I'm sticking on, just this topic. Okay, well, if you have something, I'll talk about it.
I was going to say, what happens with open houses at this point?
Open houses are a whole different animal. Now, when I say different animal, I don't mean they're not like landmark differences, but there's forms that CAR has, once again, to allow you to confirm agency relationships. And it's like an open house, it's like the OHM form. What is it called?
It's like a sign-in sheet.
Yeah, like a sign-in sheet. So there's other forms, and there's 2 different versions of it. It's an open house form, and they'll allow you to confirm with each potential buyer whether they're represented or not, whether they want you to represent them, and then technically at an open house, the way that CAR and NAR want you to do it is they want you to have agency disclosure, the BRBC, and then these open house forms like already in triplicate, so that if you see people, then you can have them sign them right on the spot. I think that's just beyond stupid. I mean, an open house is hopefully a busy enough event, and shuffling a bunch of paperwork is just going to be stupid and distracting.
Enough.
and a total turnoff. So I'm gonna vary and differ again from their recommendations and say, just show the damn house and just get it sold. And then we'll worry about all the stupid paperwork after that. I mean, again, I have clients, I've been doing this, remember, almost 30 years. And I have clients every year that say, I want you, Mr. Fehlman, to tell me how I can avoid lawsuits and claims 100% of the time. I do not want to be sued, so I want to be 100% safe. What can I do? And I said, surrender your license. Because you will always have risk if you're doing business. It's the name of the game. So what I'm telling you now is I'm giving you the best path to minimize your risk and maximize your business without, if you follow NAR's guidelines and CAR's guidelines as they're presented today, you will lose business.
Yes,
100% you will lose business. You can't do it. I know that. You know that. They don't know that. So what I've done is I'm giving you the best path to comply with most everything that's important and still have clients so that we can still have our own homes. And we go out to dinner.
Can I ask
and
one
do
more
things.
question?
Yes, ma'am.
So on the listing agent side, do they have the ability to ask if you're calling and saying, how much are you offering? Are you offering compensation? Or
You can ask that all day long.
can that listing agent say, send over your BRBC, because they want to do everything they can to protect their seller's money and not have to pay out commission if they see that the buyer has the ability to pay?
I don't think the BRBC is technically designed to be a precondition to an offer.
Okay.
But that having been said, if that makes or breaks the deal,
Yeah.
then just have your client sign one at 4% and send it over to them. If they want to play that game, then we can play that game. And then they can see that, and then we can work with it. I mean, that's why I'm saying, when you have a BRBC sign, that's why I'm gaming for 3 on every one, even though you know you're not likely to get that as a selling office at every one. That's kind of the standard norm that we aim for. So if we put 3 in on every single deal, or the amount that we negotiate with the seller, you're pretty much good to go on every deal. You're maximizing what you're going to take home. Again, if you put 2% or 1%, well, then you're limiting it, because if it turns out they're offering 3, then you either have to do what she said earlier, this lady over here, you either have to do an amendment to your BRBC or do a whole new BRBC and then present it. Okay? All right, yes, ma'am.
Would it be allowed, or would it be tacky to actually have a sign writers saying 2% commission offered to selling agent or something like that?
It doesn't matter, you can do anything. The whole point of, the take-home message here, if you slept through my entire lecture and don't remember anything other than when I walked in and came up to the podium, remember, only change we have is you cannot advertise cooperative compensation in the MLS, period. That's it. Everywhere else, it's legal and encouraged. Just not the MLS. You can't do it there anymore because that's what the settlement says, for no other reason. By the way, don't worry about it. There's going to be another lawsuit in 4 or 5 years that says that the buyers are not getting a fair shake on this deal because now they don't have representation because they're having to pay for it, and so now they're going to sue everybody and say that's a violation and we're going to change the law. So just wait, hang on for 5 or 6 years, it'll go back to the way it was and everything will be just like it was last week. But in the meantime, the game that we're going to play is exactly as I outlined it during this lecture. And if you keep it that simple, you won't have a problem with it. Don't get tied up in the minutia of the forms. Don't get tied up. The 21 forms, you can eliminate almost all of them and still comply with every civil code section that are required to comply with as a listing and selling agent. If there's any complaint that I have about CAR is the forms are largely overkill and verbose. I bought my first house, I've shared this before, and I still have a contract, in 1984. 1984. And there's a whole lot, there's a backstory there because I was underage. But nevertheless, I did get my dad to co-sign. But the contract, the RPA, what did it look like? Anyone want to take a gander what my RPA?
3 pages.
It was a 2-page agreement. My RPA was 2 pages. Yeah, the first page had the terms, and the second page was liquidated damage, mediation, and arbitration. And then my signature line. And it's a 2-page form, and I was 17 and I knew exactly what it meant. I didn't need a lawyer to look at it. And we got the job done. So you can work well with a 2-page form. Now we got 16 pages and 170 auxiliary pages. And now nobody knows any of it. So are we better off with CAR forms? Probably not. But do we have to use them? Yes. And I'm just telling you, the simple way to take advantage of this situation is to do exactly as I outlined today, and you guys will kill it, because you don't need to get lost in all the rest of the documents. And keep in mind, another bit of good news is I've heard this, there's been a lot of attrition from our profession lately as well, because agents are afraid of everything that's happening, and they're jumping and they're going to truck masters. And so what that means is whoever's left standing has what? More work. They have more jobs. They have more opportunity. So I don't look at anything that's happening as changing our profession, mine or yours, in any material way. All I see, it's like a thorn. It's a nuisance. And we're going to just work around it and get it done. And just remember, keep it simple. Just walk through my 3-step process. And then we'll figure out everything else as we go along. But if you keep it that simple, you're going to be able to kick deals out just like you did before, with very, very minimal intrusion and interference. Okay? Anything else? Yes, ma'am.
Okay, I just want to get paid. So here's the thing. Here's the scenario. Listing agents giving 1.75%. They're not offering any more than that. I charge 2.5%. I already have a BRBC. Buyer agrees to my 2.5%. Already signed the contract, everything, we're in escrow. Do I add an additional addendum stating that the buyer is to pay the difference in commission and send it to escrow along with the BRBC?
I don't know. I mean, that would be one way to do it. There's many ways we can skin the cat. We haven't seen it yet.
Okay.
So I would try that. That's how it would start. Or you can just have them pay outside of escrow. Doesn't matter.
Okay.
I mean, I'd probably keep it separate. That would be my view, just because that particular arrangement is not part of the escrow process.
Okay.
So I'd probably keep it outside would be my. What's that?
You can have a buyer pay you out of escrow?
I think so. Pay the broker.
Yeah, they're supposed to pay the broker directly on the BRBC.
Yeah, on the BRBC, they're supposed to pay the broker directly. So I'd probably go that direction and have them pay the broker directly. That way it's not part of the transaction.
Okay.
Because what happens if they don't pay and you have an escrow instruction form to pay, now all of a sudden you have sort of an incomplete, you can't close it.
Okay.
Due to what's owed to you outside of the escrow separately. So I probably might, and again, we haven't seen any of this play out yet.
Right.
But based on the way the form's drafted, it envisions a payment directly to the broker outside of the escrow.
Okay.
So I'd probably work with that first.
Okay.
Okay, if you get them to pay. All right, going once, anything else? Going twice. Let me say I have some confidence, high level of confidence, I'll be back in the next 30 to 60 days. So if you remember a question, hang on to it. I'll see you guys in 30 to 60 days.
Are you gonna have a new book out?